Lawyers, what's the most obscure law that you've actually used in a case? One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him but also doesn't turn on their headlights. Eventually they pull the man over and find that he has a lot of C in the cab of his trunk. Charges are brought for possession with intent to distribute. They get to court, and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 feet of your vehicle. Because the police officer was also driving without headlights, the man had no reason to see them, and therefore he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of the C was fruit of the poisonous tree. That is, any evidence that is discovered improperly must also be excluded. Case dismissed. I hope that guy paid his attorney well because that attorney just got that dude out of some serious prison time. A law professor of mine was representing someone who owned a goose and was being sued by a neighbor because the deed said no geese. When the deed was written, the singular and plural weren't interchangeable. Professor said deed only said no multiple geese and one goose was okay. Judge agreed. Judge was tired of hearing about a goose. Work for a debt collection law firm and we also do some subrogation work. State of Michigan has a law on the books from back in the day whereby cattle are exempt from liability in automobile accidents. Case involved an accident due to the cattle going across the road pretty suddenly and there was a car on cattle collision. Guess who got blindsided in court by this law from the 1800s? My maritime law professor was a glorious butthole and I'll never forget this story he told. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days, had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club were right near my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded. So he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member, but because he was in the public access section of the beach, legally they couldn't do anything. The Police and Criminal Evidence Act, 1984, permits the police to take a sample of semen from a suspect in custody. I had to give advice to a public entity about the US flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was what kind of remedy was enforceable under the flag code for a violation. The answer, none. Petty, upset employee got no satisfaction. I haven't used it yet, but the other day while researching a related issue I stumbled across a 100-year-old case that said summons served on Sundays were null ab initio. Hasn't been overruled, although it's probably dead letter. If I ever have to dispute a summons that was served on a Sunday I might pull it out and see how it goes. When I worked at the Court of Appeals I had a case about ferries and half of the relevant law was from 1830s to 1940s. Real weird. A client of mine was writing a scathing review of the Australian court system which he intended to publish in a book. When advising him regarding defamation etc., I ended up dredging up an old Australian law of scandalizing the courts whereby a person commits an offence if they incite disenchantment or distrust to the extent that it undermines public confidence in the judicial system. I cited a 1500s case from the UK on gravarobbing that stated that property can never be ownerless in a dispute over the ownership of a pile of dirt. I also cited a 1700s case on interpreting the rule against perpetuities. As a lawyer, I just had war flashbacks when I read rule against perpetuities. I don't know if this would be interesting to anyone else, but I drafted an MSJ last year where an insured inland marine trucking company had mistakenly delivered a filled cargo container back to port instead of the client, and it was shipped back to China where it was held by customs and the cargo was eventually destroyed. The insured's policy did not cover mishandling, misdelivery or misplaced cargo but provided coverage for all non-excluded losses. They tried to argue that, in misdelivering the cargo, they had lost it and, thus, it fell under the policy as a non-excluded loss. It only took them a week or so to locate the cargo on its way back to China, so it was never lost, but they still tried to claim that a loss in an insurance contract included anything lost. Dumb as crap argument, but the partner took out my entire section addressing the definition of loss, as in to lose, and loss in an insurance context, as in the monetary value of insured property, and we lost the MSJ. I'm, thankfully, no longer in commercial property insurance defense, but that one really annoyed me because it was such an obvious mischaracterization of the contractual language and such a stupid move by the partner. It's amazing how many eye rolls I get by lazy attorneys when they read my MSJs. Yes, I realize you think this is obvious, but if we take it out, the argument is no longer foolproof. If you are entitled to a judgment as a matter of law, you shouldn't have any missing factual logic. We read a contracts case back in school that ultimately came down to the issue of whether a hot dog was a sandwich. There's a Supreme Court case about whether a tomato is a fruit or vegetable. I didn't, but worked in an insurance litigation firm where a guy used an 1800s maritime law to defend a case that occurred on a boat on Lake Michigan. He wanted to get it out of state court and into federal court where civil verdicts usually have less value in our area. That was neat. I routinely cite a 1921 case regarding a forged railroad ticket when I'm trying to argue the best evidence rule of an original that's later been marked up with pen or has some notes on it. The case says that if something is printed out containing all the elements of what it's trying to do, then any handwriting on it is evidence that it's been altered, and the alterations must be shown to be lawful by whomever seeks to enter the item into evidence. Very good to use to keep things out of evidence. Citation, please. Car sales tax case. Client has to post amount of disputed tax and then ask for the money back before getting an opportunity to sue to get money. There are also interest and penalties. If you do not send a letter asking for the state to not pursue, state can still go after client even though case is pending. On the letter to request the state not pursue, at the top must be written in red ink specific words, or the state can ignore the letter per the regulation. This case has been going on since 2006 and haven't been able to file a case yet in court. Also, state never actually has to respond to the request for refund. Obscure case, but frequently found in tax law to say the taxpayer is allowed to minimize tax liability. The Inland Revenue v. the Duke of Westminster, or commonly known as the Duke. Case is about whether the Duke is allowed to fire his gardener and give him an annual gift in exchange for his services. Nothing changed except now he can deduct tax on the amount. I used the statute of bastardy from Connecticut in a brief I wrote in law school. It was a criminal statute that provided the colonial US equivalent of child support. The legal definition of massage is so ridiculously overbroad in my state that it literally covers getting water pumped up your colon to clean out all the poop. We have a statute that prohibits certain kinds of car insurance from reimbursing providers for massage. I was dealing with this shady fly-by-night clinic that offered a bunch of bull services that didn't do anything. They were really just a massage parlor that pretended to do other crap to get around the billing issue. So I argued that everything they did was technically massage under the statute. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. Obligatory now, but I work at a lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification of many that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently nobody did, though. Nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification, even though the dude really was speeding. Allegedly speeding. We will never know since the officer with the radar gun didn't have the proper certificate. He might have mishandled the radar gun or used it on another car. Typical mistakes for those who aren't certified. Where I went to school, the conservation law students had to do a paper on if hunting on horseback is considered hunting with the aid of a motor vehicle here in NY. The answer isn't what you think. I knew a guy who got a DUI on a horse in upstate. Not surprised at your answer. Canada has an apology act stating saying sorry does not show responsibility or take blame for the situation you may or may not be at fault in. The Apology Act wasn't passed until 2009. When I was taking driver's ed before this happened, they specifically taught us not to apologize after an accident because it could be deemed an admission of guilt. Asking a Canadian to not say sorry after a car accident, regardless of fault, is like asking a dog not to bark. It's just what they do. Not a lawyer but know of a weird law for hunting. You are not allowed to claim deer roadkill if you are not up to date on your child support payments. I had a competition with my brother, also a prosecutor who could cite international shoe first, jurisdiction for minimal contacts and fair play. I won in a hearing over forcing an out-of-state adult book company to accept a subpoena. It's obscure case law, not a statute. A co-worker of mine used a court decision from the 1880s to successfully defend a document someone was trying to invalidate over an issue concerning a notary stamp. The stamp was clear enough to read, but had a slight smudge that the other side argued made it invalid. They were able to keep the document out in an administrative hearing, and won the case on that level based on that. We appealed it to district court. My co-worker found a case from the 1880s where the court described a notary stamp smudged in the same way and ruled it was valid. This was the only case she could find that addressed the issue. Based on that precedent, the district court overruled the administrative court and reversed its decision. Sir, I'm not here to have a philosophical debate about civil engineering. When the judge starts with the sass, you've already lost. I do remember hearing a story where this guy in Michigan was arrested for underage drinking, but was only a couple of months away from turning 21. He went to court and pulled out an abortion law for Michigan stating that life begins at conception. So when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, he was technically over 21 years of age and legal to drink. The case was dismissed, and when the prosecutor made a stink about it, the guy said, "Hey, it's your rules." About 5 years ago, the managing partner of my Chicago firm made me write a motion for a writ of mandamus in a federal case we'd filed in California. The judge generously denied my motion without making me fly out to defend it in front of her. I am waiting for a chance to use my state's laws regarding Proud B. One statute requires B to be confined while proud for a certain period of time. Another statute provides that there is no liability for killing a Proud B that is not properly confined. Obviously, this refers to female dogs in heat, but the term proud is not defined anywhere in the state code as it relates to B. Now, but, in the 60s, my hippie brother was busted for a traffic infraction in Hingham, Massachusetts. While being patted down, he farted in the cop's face. He was charged with a colonial-era law, uttering in public, and fined. I miss him. I'm no lawyer, but there's a case that took place in the UK court. Her Majesty's Revenue and Customs, HMRC, v McVitie's. McVitie's make a biscuit called Jaffa Cakes and HMRC argues that they were a biscuit and subject to taxation. McVitie's argued that they were in fact a cake and cakes aren't subject to taxation. McVitie's made a bigger version of a Jaffa cake, cake size I guess, and argued that cakes go hard and biscuits go soft. The Jaffa cake went hard and McVitie's won the case. It's quite common that a jury will convict a guy but the conviction is overturned because the prosecution didn't present sufficient evidence of one of the elements of the offense. In an extremely rare version of this legal principle, my brother-in-law just had a case where the prosecution will forgot to present evidence proving the crime took place in the geographic jurisdiction, like county or state of the court. Jurisdiction must be proven like any other element of a crime. The closest they got in this case was someone's testimony that it happened at home. Conviction reversed. Defendant is free to go. When I was in college, a girl who worked at an expensive law firm told me this and I always wondered if it was true. She said that when Oklahoma passed a new drunk driving law that they specifically mentioned the breathalyzer machine that the cops had to use, and since it was a new one most places didn't have it. So if you got a DUI and they didn't use that machine or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used or could have used the old ones. She said they had gotten cases dismissed using that argument. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.